Hello and welcome to Bulletin 133. Three interesting cases are referred to in the Bulletin. The first is Ratigan and Hanna, and in that case the executor was being sued by a beneficiary for alleged misconduct. The problem was that the executor, although defending his personal interests, was actually paying for the defence out of the estate. $300,000 had been expended. In the event, the judge said that that wasn't appropriate, and he ordered $270,000 to be refunded to the estate, but that those funds, because costs would follow the event, he ordered that those costs be paid into court. He commented that the executor, embarking on the defence of litigation where he expected the estate to pay, or as it turns out, in some events, the prosecution of litigation, was a matter that if the executor wanted the protection of the court and the estate to be liable for the expenses, ought to be getting an order from the court, or judicial directions, often called a rebetto order. I think that is a salutary reminder when there's litigation involving executor and estate being expected to pay costs, etc. The second is a family provision application, and it really revolves around the jurisdiction of the district court. The estate was $2.3 million, and the parties had agreed that the three applicants receive a total of $930,000. The jurisdictional limit of the district court, $750,000, so the argument was it within the jurisdiction of the district court to be able to, in effect, make an order in terms of the agreement that had been reached by the parties. The judge found that each of the claimants, what they were to receive under the settlement that had been reached, was not above the jurisdiction of the district court. That is, not more than $750,000, although in total greater than $750,000, and considered, based on authority, that the district court had jurisdiction in the matter. Finally was a very interesting case of construction of a will. It's Re Hamilton is the case, and there a reference in the will to a Mr. Brian Hogan was mysterious to some extent, because there was no such person remotely associated with the affairs of the deceased. And the other legatee, her husband was Brian, and he alleged that the legacy was intended for him. In the event, that's what the court found. They said that the most weighty factor was that there was no other person other than the first defendant who could reasonably be construed as being intended by the testator to be the beneficiary, and thus succeeded. However, again, a little salutary thing, the judge commented that the solicitor who read the will out to the testator before the testator signed it, it was a bedside situation, commented that the solicitor should have both deposed in greater detail to the manner by which the testator had confirmed each clause of the will, and also recorded any comments made by the testator, that is, better recorded them. So I guess it's a reminder that when we're in these situations, that it's very important to keep good quality file notes. Thank you.